No, the court's not going to include college costs in your parenting plan. No, your parenting plan is not going to include who is going to be responsible for buying your child a car when he or she comes of age. No, the court's not going to decide who pays for your child's wedding. And really quick, if you're new here, I'm a lawyer and I'm also the owner of Strategic Family Law, which is a marital and family law firm in Florida. I've recently become aware that there's a class out there that certain individuals are offering to divorcing parents that coaches them on what they should ask for when they're negotiating their parenting plan. I'm sure these classes are very well intentioned, and of course, there are definitely certain provisions that you should not forget to include in your parenting plan. So I get all that. But the sad truth is that the court is very limited as to what it can put in your parenting plan, and a lot of these terms and provisions are very unrealistic and sometimes impossible. The court is powerless to include provisions about what is going to happen with your children beyond the age of majority, which is why I mentioned items such as your child's car or your child's wedding or your child's college. These are things that more often than not happen after your child has turned 18. The court has no power to make decisions beyond that age. And even if some of these things happen before your child turns 18, such as getting a car for their 16th birthday, the court doesn't have the power to make decisions about these extraneous gifts that aren't really for the child's survival or basic well-being. So, unfortunately, I've noticed that certain clients come in with these false expectations about what they're going to get in their parenting plan, when the hard truth is they can't ask for these things in a court setting. Now, the solution would be to go to mediation and try to negotiate these things with your soon-to-be former spouse, because in a mediation or settlement setting, the world is your oyster. If you and your former spouse want to agree to these things, you're free to do so. But if he or she won't agree, there really isn't any leverage to go to court and ask for these things, because the court likely will not give these things to you. Moral of the story, number one, be careful with these courses out there that give you false expectations as to what is possible in your parenting plan. And number two, do your best to try to reach an agreement. That is your best shot at getting the most comprehensive parenting plan that you could get. If you decide to go to trial on all your parenting issues and you ask the court to design your parenting plan, then just get ready. It is going to be a very basic parenting plan that likely does not touch on the issues that you are most concerned about. And as always, if you need help with this, call me. Let's talk it through.